Ladies and gentlemen of the jury, the defendant has been arraigned on the charges and has pleaded not guilty, and of this he puts himself upon his country for trial, which country you are. The Attorney General for the state has joined the issue, and you are to say by your verdict if the defendant is guilty of the crimes whereof he stands charged or not guilty. Hearken to the evidence. Mr. Duren, you may be seated.
Okay, thank you, Clerk Covalenco. Good morning again, members of the jury. Thank you for your punctuality. Thank you for your service. Okay, you are about to hear opening statements by counsel. Before that, I'm going to give you some general instructions as to the law that applies to this case, which will give you some guidance as you consider the evidence in this case. At the end of the case, after you have heard the evidence and closing arguments, I will give you further instructions, and then you will retire to the jury deliberation room to decide your verdict. You will receive a written copy of these instructions when you are ready to deliberate. In order to reach a fair and just verdict, you must understand and follow the law as I explain it to you. For example, you have to understand the definitions of the crimes with which the defendant is charged. You have to understand how convinced one way or the other you should be before you reach your verdict, and you have to understand what to consider in deciding whether to believe a particular witness. These instructions, as I said, will explain the law as to these and other matters so that you can reach a fair and just verdict. It is up to you to decide the facts of this case. You and you alone are the judges of the facts. You must decide the facts solely from the evidence in this trial. You apply the facts as you find them to be to the law as I give it to you in these instructions, and in this way, you reach your verdict. You should decide the facts in this case without prejudice, without fear, and without sympathy. You are to decide the facts based only on the evidence, and the evidence in this case consists of the testimony under oath of the witnesses and any exhibits which are admitted into evidence. Those exhibits will go with you into the jury deliberation room. There are certain other matters that you may not consider as evidence. The fact that the defendant has been arrested and charged with a crime is not evidence of his guilt. In this case, the defendant was charged by means of a document called an indictment. An indictment is simply a way of giving the defendant notice of the accusations against him. This type of document is a formal way of accusing him of a crime in order to bring him to trial. In your deliberations, you must not consider the fact of the defendant's arrest, the indictment, or the defendant is being brought to stand trial as evidence of the defendant's guilt. The possible punishment the defendant may receive if you return a guilty verdict should not influence your decision. The duty of imposing sentence is solely for the judge, and you should consider the evidence presented and base your verdict only on the evidence without considering the issue of punishment. What the lawyers say to you is not evidence. In their opening statements and their closing arguments, the lawyers will discuss their view of the facts to help you understand the evidence from their point of view. But the lawyers are not witnesses in this matter, and therefore they cannot testify. Therefore, what they say to you is not evidence in the case. If the lawyers state the evidence differently from how you recall it, then you should follow your own memory of what the evidence was. Also, if the lawyers state the law differently from the law as I explain it to you in these instructions, then you must disregard what the lawyers have said about the law and follow my instructions. It is quite common during a trial for the lawyers to make objections. Lawyers are supposed to object when they believe that certain evidence may not be admissible under our rules of evidence. Please do not hold it against either party if they make these objections, and sometimes these objections require bench conferences. If I sustain an objection and I exclude any evidence, you must not guess as to what the evidence might have been. If I order that a question and answer be stricken from the record, you must not consider either the question or the answer as evidence. Likewise, if I overrule an objection and I admit certain evidence, then you must not give that evidence any special weight as a result of my ruling. I am not expressing views as to the importance of evidence when I make my rulings. I am merely applying the law, as is my duty. Throughout the trial, I must be fair and impartial, just as you are required to be. So if I say or do anything during the trial that causes you to believe that I favor one party over the other, I now instruct you that I do not favor either party in this case. The role of the judge is to run the trial in a fair and orderly manner, to decide the admissibility of evidence, and to instruct you, the jury, on the law that applies to the case. You, and you alone, as I said, are the judges of the facts, and you decide the verdict. Now that I've told you what you must not consider, I'm going to tell you what you can consider as evidence. You should consider the testimony of witnesses and any exhibits that may have been introduced as evidence. In other words, you should consider only the legally admissible evidence and reasonable inferences that you can draw from the evidence. By reasonable inferences, I mean conclusions which reason and common sense lead you to draw from the facts that are proven to your satisfaction. There are two ways for a party to prove a particular fact in the case, either through direct or circumstantial evidence. Direct evidence is direct proof of a fact, such as the testimony of a witness based upon personal knowledge. That is, what the witness actually saw, heard, or otherwise directly experienced. Circumstantial evidence is indirect evidence, which tends to prove a disputed fact by proof of other facts. In other words, circumstantial evidence is proof of a chain of facts and inferences that tend to prove whether the defendant is guilty or not guilty. Let me give you a brief example to demonstrate the difference between direct and circumstantial evidence. Assume that when you enter the courthouse, it is cloudy outside. While you are in the court, you see someone come into the building who is wearing rain boots, the person is soaking wet, and they're closing an umbrella. If you could actually look out the window and see for yourself that there is rain falling from the sky, that would be direct evidence that it is raining outside. In contrast, if you cannot see for yourself whether it is raining outside, you still could consider the facts and circumstances of the person you observed entering the court with the rain boots and umbrella to determine whether it is raining outside. That is an example of circumstantial evidence. You should consider both types of evidence, direct and circumstantial. There is no legal distinction between the weight of direct evidence as compared to circumstantial evidence. You are permitted to give equal weight to both, but you must decide how much weight to give any evidence, whether it be direct or circumstantial. There is, however, a rule relating to circumstantial evidence that you must keep in mind. If the state presents only circumstantial evidence to prove one or more elements of a charged offense, then in order to convict, you must find that the totality of the evidence as to those elements excludes all reasonable conclusions other than guilt. This means if it is reasonable to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the reasonable conclusion consistent with innocence. In determining whether all reasonable conclusions other than guilt have been excluded, you should not consider any item of circumstantial evidence in isolation. Rather, you should consider each item of circumstantial evidence in the context of all the other evidence. You must understand, however, that this circumstantial evidence rule does not apply to direct evidence. If there is a conflict between two or more witnesses who offer direct evidence concerning certain facts, you must decide which witness to believe. For example, suppose there are two eyewitnesses to a crime, and one testifies that the defendant committed the crime, and the other testifies that the defendant did not commit the crime. This presents a situation where there is a conflict in the direct evidence. In this situation, you, the jury, must decide which witness to believe and whether, based upon all of the evidence, the state has proven the defendant's guilt beyond a reasonable doubt. Similarly, if only one witness provides direct evidence concerning an offense charged, then you must decide whether to believe that particular witness, considering the factors I will outline and any other considerations you would ordinarily use in deciding whether to believe a person based upon your common sense and good judgment. Now, in reviewing the evidence, you should consider the quality of the evidence and not the quantity. It is not the number of witnesses or the quantity of the evidence that is important, but the quality of the evidence. That is, how persuasive the evidence is to you. In summary, you should consider all the evidence in the case and decide whether the state has proven the defendant guilty beyond a reasonable doubt. In deciding this case, you must decide the credibility of witnesses. That is, it is up to you to decide who to believe. If there is any conflict between the witnesses, then you must resolve the conflict. Simply because a witness has taken an oath to tell the truth does not mean that you have to accept the testimony as true. Use your common sense and judgment. Consider factors you use in deciding important issues in your everyday lives. For example, you may consider the following: the witness's appearance, attitude, and behavior on the witness stand and the way the witness testified, the witness's age, intelligence, and experience, the witness's opportunity and ability to see or hear the things about which the witness testified, the accuracy of the witness's memory, any motive of the witness not to tell the truth, any interest that a witness had in the outcome of the case, any bias of the witness or friendship or animosity the witness may have for or against any of the other people in the case, the consistency or inconsistency of the witness's testimony, whether or not what the witness said appears reasonable or unreasonable, whether what the witness said is consistent or inconsistent with the testimony of other witnesses or with statements the witness made at another time. In deciding which witnesses to believe and how much of their testimony to believe, you should consider both the direct and cross-examination of the witnesses. If you believe that part of a witness's testimony is false, you may choose to distrust other parts also, but you are not required to do so. Inconsistencies and contradictions within a witness's testimony or between witnesses do not necessarily mean that you should disbelieve the witness. It is possible for honest people to witness the same event and see or hear things differently. You should evaluate inconsistencies and contradictions and determine whether they are important or unimportant. You need not believe any witness even though the testimony is uncontradicted, nor are you required to accept testimony as true simply because some or even all of the witnesses agree with each other. You may find the testimony of one witness or of a few witnesses more persuasive than the testimony of a larger number. The principles I have outlined regarding judging the credibility of witnesses apply to all witnesses, whether they are ordinary civilians, police officers, or otherwise. In short, you should consider the testimony of each witness and give it the weight you think it deserves. You can accept all of what a witness says, you can reject all of what a witness says, or you can accept some of it and reject some of it. It is up to you. Now, I've addressed what you should not consider and what you should consider in reaching a verdict. I am now going to discuss how convinced one way or the other you must be, and this is referred to as the burden of proof. Under both our state and federal constitutions, all defendants in criminal cases are presumed to be innocent until proven guilty beyond a reasonable doubt. The burden of proving guilt rests entirely on the state. The defendant does not have to prove his innocence. The defendant enters this courtroom as an innocent man, and you must consider him to be an innocent man until the state convinces you beyond a reasonable doubt that he is guilty. If, after all the evidence and arguments, you have a reasonable doubt as to whether the defendant committed any one or more elements of the offense, then you must find him not guilty. Ladies and gentlemen, a reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based on reason as remains after consideration of all the evidence the state has offered against it. The test you must use is this: if you have a reasonable doubt as to whether the state has proven any one or more of the elements of the crime charged, you must find the defendant not guilty. However, if you find the state has proven all of the elements of the offense charged beyond a reasonable doubt, you should find the defendant guilty. During the course of the trial, you can get to know your fellow jurors, but you are not allowed to talk about the case or the evidence until you begin deliberating. It is quite natural to want to talk to your fellow jurors about the case as it unfolds, but it is really important that you not do that. If you have those conversations during the trial, it tends to cause you to form opinions about what you think the outcome ought to be before you have heard all of the evidence. Cases are presented in a certain order. The state has the burden of proof, so it will present evidence first. Because the defendant is presumed innocent, he has no obligation to present any evidence, but he has a right to do so if he wants to. So you may not hear evidence from the defense until later in the case. If the defendant chooses to exercise his absolute constitutional right not to testify or present any evidence, you cannot hold that against him or draw any negative inferences based on this. Even if the defendant chooses not to Even if the defendant chooses not to present evidence, the importance of certain pieces of evidence may not become apparent until the lawyers make their closing arguments. You will have plenty of time to discuss the evidence and testimony with your fellow jurors when you retire to deliberate. After all of the evidence has been submitted and both sides have presented their closing arguments, I will give you further instructions about the law that applies to this case, including definitions of the crimes charged and other issues that might arise during the course of the trial. If at any point, if any of you cannot see or hear any witness or any of the attorneys while they have the floor, please raise your hand and we will address it. Thank you. The other thing I would like to say at this time is we typically will take a mid-morning break, we'll take a lunch break, and we'll take a mid-afternoon break. I try to time those breaks based upon the overall flow of the trial and based upon the presentation of witness testimony. I try to do my best to make sure that we don't go too long, so we'll do that as we go through the evidence. Okay? All right, ready to proceed?
This is Caitlyn Naffziger. You can see her here with her daughter, Ellen. In this photo, you can see her as she was in life, holding one of her children close. She's dead now. She's dead because the defendant, Dustin Duren, the father of her children, murdered her. As Caitlyn sat on the couch, holding her 4-year-old daughter, Ellen, on her lap, very much like you see there, the defendant ripped Ellen from Caitlyn's arms. He stepped back, pointed his 9mm Beretta semi-automatic pistol at Caitlyn's head, and pulled the trigger. The defendant was still holding Ellen in his arms when he murdered her mother. The sound of the gunshot hurt Ellen's ears. After the defendant killed Caitlyn, he took Ellen and her 1-year-old sister, Valen. He packed their things, put them in his car, and began driving. He got all the way to Concord, where he called his parents, and he confessed. He told them that he had killed Caitlyn. He said he was going dark, and he shut off his phone, making it impossible for the authorities to track his location. The defendant's father called the Berlin police. The police went to the defendant's apartment and found Caitlyn there, dead. A few hours later, in the early morning hours of March 1st, 2024, an Amber Alert went out, including descriptions of the defendant, the girls, and the defendant's car. It was that Amber Alert that led to the defendant's arrest, after a citizen told the Keene police that she saw the defendant's car heading in the direction of an Applebee's in Keene. The police found the defendant in his car in the parking lot of Applebee's. Ellen and Valen were in the back seat. The murder weapon, that 9mm Beretta semi-automatic pistol, was in the driver's side door. After his arrest, the defendant gave an interview with the New Hampshire State Police. He told them his version of the story, his version of what happened between him and Caitlyn. He told the police that he wanted Caitlyn to leave his apartment, and when she wouldn't, he got angry. He tried to take Ella away from Caitlyn, but she refused, and he got angry. So he went to his desk, grabbed his gun, and used it to kill the mother of his children. You can see the words "very deliberate" up there on the screen. Those are his words, the defendant's words. Those are the words that he used to describe his killing of Caitlyn Naffziger when he spoke to the police. Ladies and gentlemen of this jury, this will not be a case that is difficult to understand. This will not be a whodunit. There will be no mystery. The evidence will prove to you beyond a reasonable doubt that Dustin Duren murdered Caitlyn Naffziger. The evidence will also show you why he did it. This is a case about anger and control. According to the defendant, he and Caitlyn had argued over the course of the day. He wanted her to leave and go back to Minnesota, where she was from. And when Caitlyn refused to do what he wanted, when he couldn't control her actions, he got angry. So he took his gun, pointed it at Caitlyn, and pulled the trigger. It was, as he said, a very deliberate act. During this trial, the state will provide you with evidence that proves beyond a reasonable doubt that Dustin Duren is guilty of the murder of Caitlyn Naffziger, as well as the crimes of reckless conduct with a deadly weapon and endangerment of a child. You will be given that evidence in the form of witness testimony, photographs, videos, and physical evidence. And right now, we're going to talk about some of that evidence. Caitlyn Naffziger and Dustin Duren were both from Minnesota. Together, they had two daughters, Elowyn and Valen. In February of 2024, Elowyn was 4 years old, and Valen was 1. Caitlyn and the defendant did not have a good relationship. It was rocky. By January of 2024, things were not in a good place. That month, the defendant moved from Minnesota to New Hampshire. He brought Elowyn with him. Caitlyn and Valen remained in Minnesota. The defendant drove from Minnesota with Elowyn, and on January 23rd, he moved into an apartment in Berlin. That apartment was at 1063 Main Street. You can see 1063 Main Street here. It's a multi-family home in Berlin. The defendant's apartment was on the ground floor. After the defendant and Elowyn arrived in New Hampshire, the defendant and Caitlyn argued over the phone and through text messages. They argued about the children and their future. On February 27th, Caitlyn and Valen flew to Boston. They took a bus from the airport to New Hampshire, where they met family, and they spent the night with that family on the seacoast. The next day was the 28th. That day, Caitlyn and Valen got a ride and were dropped off at a restaurant in Ossipee. There, they met the defendant and Elowyn. After having lunch, the defendant drove them all in his car back to Berlin. They spent the night at 1063 Main Street, that apartment that you saw. The defendant believed that after this visit, Caitlyn was going to return home to Minnesota without either of the girls. That was what he wanted. The next day, February 29th, according to the defendant, he asked Caitlyn repeatedly when her aunt was going to come pick her up. He asked her every 15 minutes because he wanted her to leave. He didn't want her there. Caitlyn ignored him. After repeated questions from the defendant about when she was going to leave, Caitlyn told him, "I'm not leaving, I'm staying." During the course of that day, according to the defendant, Caitlyn threatened to call the police and have the children taken away from him. This continued throughout the day. That evening, after a day of asking Caitlyn when she would leave, and a day of Caitlyn not doing what he wanted her to do, the defendant got angry. He was so angry that he started packing up Caitlyn's things so that he could drive her to the seacoast, do it himself. His plan was to load Caitlyn, her things, and both girls into the car, drive Caitlyn to her family and drop her off, and then return back to Berlin with both of the girls. The defendant put the younger daughter, Valen, in her car seat. Caitlyn remained sitting on the couch, holding Elowen in her arms. Similar to that photo. Caitlyn did not want to leave. The defendant tried to grab Elowen from Caitlyn, but Caitlyn would not let go. She continued to hold Elowen. She didn't want to leave. This made the defendant even angrier. Angry that Caitlyn refused to leave his apartment, and angry that she refused to let go of her daughter Elowen, the defendant had had enough. In his mind, the line had been crossed. Those are his words. Those are the words he told the police, and he described to them why he killed Caitlyn and what was going through his head. By refusing to allow him to take her child from her arms, Caitlyn had crossed the line. This is a diagram of the defendant's apartment at 1063 Main Street. If you look at the living room, you can see that there is a couch, a coffee table in front of it, and then a desk on the other side of the room. Those black bars that you see represent the doorways in the apartment. And you can see the back door is down a hallway on the left side. Caitlyn was sitting on the couch in front of the coffee table with Elowen on her lap. According to the defendant, after he tried and failed to take Elowen from Caitlyn as she sat on the couch, he crossed the room and went to his desk. From his desk, he grabbed this, his Beretta 9mm semi-automatic pistol. That gun had a loaded magazine in it, but no bullet in the chamber. According to the defendant, after he grabbed the gun, he racked it on the slide back, putting a bullet in the chamber. The gun was now ready to fire. The defendant walked back across the room from his desk, around the coffee table, and stood in front of Caitlyn to her left. He grabbed Elowen and ripped her from her mother's arms with his left arm. He was holding that pistol in his right. After grabbing Elowen, holding her in his left arm, he stepped back and pointed his gun at Caitlyn's head. At this point, Caitlyn was sitting on the couch alone. She was unarmed. The defendant stood between Caitlyn and the exit. Elowen in one arm, gun in the other. At that time, Caitlyn did not have a car. She did not have a bus ticket, and her family was hours away. As Caitlyn sat on that couch, holding Elowen in his arm, after stepping back, the defendant pulled the trigger. He did not miss. He fired one bullet. That bullet entered Caitlyn's skull from the left side of her head. It traveled through her brain and exited the right side. The gunshot was loud. According to the defendant, Elwyn immediately started grabbing her ear and complaining of the noise. The defendant went to the garage and put her in the car. This is what the defendant told the detectives later about what he was thinking at that moment after shooting Caitlyn in the head. He told them that he knew, in his words, that he was screwed. He understood what had happened, and he understood the consequences. He went back in the house. He got Valen, who was still in her car seat. He grabbed clothes for himself and for the girls. He grabbed food and water. He grabbed pillows and blankets. He put all of these things into his car. He grabbed his desktop computer. You can see it there in the defendant's trunk. After packing up those supplies with both girls in the car, the defendant started to drive. The defendant left his apartment in Berlin sometime between 5:38 p.m. and 6 p.m. on February 29th. He drove to Concord, arriving a little bit before 9 p.m. In Concord, the defendant sent a video of the girls to his mother, and then he called his parents. At 10:08 p.m. in Concord, he called them and told them what he had done. He said, "I killed Caitlyn." He said, "You should probably call the police." He also said, "I'm going to go dark. I'm not turning off my phone." He said he would turn himself in, but he wanted some time with the girls before he did it. At about 10:22 p.m., the defendant did turn off his phone. According to him, he drove west into New York State. At some point, he stopped, and he and the girls slept in the car in the back seat. According to the defendant, when he woke up the next morning, he decided to turn himself in. So he started driving back to New Hampshire. As the defendant drove through Keene the morning of March 1st, he decided to have breakfast somewhere with his girls. While driving, he was seen and he was placed under arrest. The murder weapon, that 9mm Beretta semi-automatic pistol, was in the door, still loaded. That was March 1st. The evidence in this case will prove to you, beyond a reasonable doubt, that the defendant is guilty of knowing second-degree murder and the alternative charge of reckless second-degree murder for killing Caitlyn Naffziger. It will also prove that he committed the crimes of reckless conduct with a deadly weapon and endangerment of a child. The evidence will prove to you that the defendant was not provoked when he pulled that trigger, and that the killing of Caitlyn Naffziger was not justified. When asked by a detective if Caitlyn had threatened to harm anyone, he said no. When asked by a detective if he knew he was endangering Elwyn by firing a gun so close to her, he said yes. The evidence will prove to you that the defendant caused Caitlyn's death merely because he was angry and nothing more. You will hear testimony during this trial from state troopers and police officers who will describe how they investigated this case and how they gathered important pieces of evidence. You will hear from the medical examiner who conducted an autopsy of Caitlyn's body. An intelligence analyst with the New Hampshire State Police will describe for you how she used cell phone location data to map the defendant's movements before he turned his phone off. You will hear testimony from an expert firearms examiner who will tell you that the gun that fired the bullet that killed Caitlyn was the defendant's. And you will hear what the defendant told the police when they interviewed him and when he confessed. His version of the story. After his arrest, the defendant spoke with the state police at length. That interview was audio and video recorded. You will be able to see it for yourselves. You will be able to see the defendant's body language, his demeanor, and his tone of voice. You will see that the defendant was calm and in control when he described killing Caitlyn Naffziger. I've already shown you a few of the things that he said during that interview. You will see those and more presented during this trial. Those statements are just some of the evidence that will prove that the defendant is guilty. Caitlyn is dead. She is dead because the defendant became angry when she refused to leave his apartment. And she is dead because she would not stop holding her 4-year-old daughter. And that made the defendant mad. So he grabbed his gun, took Caitlyn's daughter away from her, and shot her in the head. After you have heard all the evidence in this case, it will be up to you, the jury, to deliberate and deliver a verdict. When that time comes, when you have had all of the evidence placed in front of you, you will know, beyond a reasonable doubt, that the defendant is guilty. You will know that the defendant murdered Caitlyn Naffziger. Just like the defendant knew from the moment that he fired his gun, you will know that he's guilty.
Certainly.